Hello everyone and welcome back to the University. Today we have the final 5 hearings in the Raymond Davis saga. We have August 12th, a readiness hearing and again an attempt to waive counsel. We have September 9th, this is all 2020, motion to dismiss counsel, again. September 30th, a calendar call, and in this one, I swear, Raymond was apoplectic about not being able to speak whenever he felt like it. And again, a motion to waive counsel. Then we move into 2021. We've got February 1st, a supplemental PSI, and we find that a plea deal has been entered. And then on March 8th, the final hearing, we find out that Raymond Davis has successfully completed all of his probation and the case gets closed. And I don't know about you, but this was deeply unsatisfying to me. I will be looking into this more, find out what Davis is up to these days, if I can, and find out some more about those Supreme Court filings and appeals, and see if there's anything interesting there. All right, let me know what you think about this case in the comments, and I hope you enjoy.
Versus Raymond Davis, C 342-9461. Mr. Davis is present in custody.
Good morning, Your Honor.
Good morning. Who do I have for Mr. Davis? Is Gill here?
Adam Gill, Your Honor.
Okay. The jury trial is set for October 5th on the calendar. What is your status of trial readiness?
Judge, we're just hoping to keep the calendar call and trial date. I was appointed formally last Monday, but I believe Mr. Davis has been invoked.
Okay. Ms. Clerk, can the October 5th date stand?
Yes, Your Honor, that's a good date.
Okay, sir, your October 5th date is standing at this time with a calendar call September 28th.
Your Honor, I'm looking at Waive Counsel also.
Pardon me?
I'm looking at Waive Counsel.
Yeah, I saw you ask the district court judge assigned to your case to do that, and that the judge denied it, saying you don't follow policies and procedures. I saw that in the minutes.
Yes, Your Honor, that was...
My suggestion to you is that you file another motion. I can't address it now. That's been ruled upon, and I certainly can't do it sua sponte. Do you know what sua sponte means?
Yes, Your Honor, that's fine.
Okay, so I'm not authorized at this status check calendar.
That's
I'm
more
moving dates. That's all I'm doing.
than fair, Your Honor, more than fair.
Okay, so thank you very much.
Okay, thank you.
Your Honor, I'm sorry. The calendar call will change now that it's set on the central calendar.
What's the calendar call now?
The calendar call will be September 30th at 2 p.m.
Did you get that, Mr. Gill?
I did. Thank you, Your Honor.
Thank you.
Will that be in front of Judge Blues or back in Southern?
It'll be here in 7 on the central calendar.
Okay, thank you. I have one more case. Is there any way I can get that called? Stacey?
Davis, page 14, C342946. Mr. Davis is present in custody via Blue Jeans. I also have Mr. Gill present via Blue Jeans. And then Ms. Cole, was Ms. Collins coming on this one, or are you going to be taking care of it?
I believe Ms. Collins is coming. Let me text her really quick.
Okay. I'm sorry. Okay. So we'll recall this one. Ms. Collins is present. Mr. Gill, who else do you have in custody? 946-1, State of Nevada versus Raymond Tyrone Davis. Mr. Davis is present in custody via Blue Jeans. Mr. Gill on his behalf via Blue Jeans, and Ms. Collins on behalf of the state via Blue Jeans. All right, so this is defendant's pro per motion to dismiss counsel. Mr. Davis, is there anything new? I feel like you and I are on the hamster wheel, and so I'm trying to understand this. I understand. One second. I understand that you would like to represent yourself, but like I have told you multiple times, because of your behavior during the last trial, you will not be able to represent yourself. You generally have a right to represent yourself. However, that right can be taken away if you do not act how you're supposed to act in front of a jury, which happened multiple times. So you have two choices. You may hire your own private attorney, or Mr. Gill is going to stay on this case. You have an upcoming trial on October 5th.
May I speak now? May I be heard now, Your Honor?
Yep, sure.
Your Honor, on September the 17th, 2019, you, and during lunch breaks, you told me that if my behavior continued, I would be disciplined pursuant to NRS 175-3-387. Since then, I have made over 20 court appearances, and I have not had one outburst. I have not been held in contempt of court. Right now, I have no counsel. Adam Gill does not come to see me. He does not talk to me. His staff told me not to call anymore, not to bother Adam Gill anymore. That is not, he's been on for 2 months. I sent letters, some certified. He refused to talk to me. This is not representative. This is ineffective assistance of counsel. I have a 6th constitutional right to effective assistance of counsel. Also, Your Honor, I have filed 2 complaints against Attorney Adam Gill. I've also sued you in the U.S. Your case is in the U.S. in the U.S. Court of Appeals, case number 20-16602. Also, Your Honor, I sued. You might know an officer named Kelly Bluth. I have sued him in U.S. District Court, case number 2.20-CV01630 KJD-EJY. I have also filed 2 complaints against you with the Commission on Judicial Review, Discipline Review. Your Honor, you continue to violate my constitutional rights. I have a right to defend myself. I sued you and you appointed me a lawyer. That screws on unfairness of the court. Adam Gill was appointed by you when you were facing a lawsuit by me in jail. So how is that fair that a judge that is being sued gets to appoint the counsel to the defendant?
Probably
this is
because
your
it's my
counsel.
job. I have to appoint you an attorney when you can't represent yourself. Adam Gill is one of the contract attorneys, so he gets appointed. Mr. Gill, is there an issue with the communication with your client?
Judge, my office has been over there. My associate's been over there, I believe, twice, and my investigator as well. I've received a phone call from Mr. Davis. My office has instructed him that calling every day is not going to be fruitful for him. He did notify my staff of a 1983 lawsuit against me that he filed, and at that point I'm not going to play the game and continue to go back and forth with Mr. Davis if that's all he's interested in.
So, Mr. Gill, let you in on something that Mr. Davis does. When he doesn't like something that's happening, he then sues that person, or he turns them into the bar, which is what he did to his last attorney.
He did also mention that, Judge.
Right,
I'm sorry to interrupt, but I've also apparently been taken to the bar by Mr. Davis.
So I spoke to the chief judge about this, who explained to me that trying to get your attorney to get off the case by suing them is not a legal remedy to get a new attorney or to represent yourself. So we're going forward as is. This is set for a status check for the central calendar call on September 30th, and it has a central jury trial date of October 5th. Defendant's pro-promotion to dismiss counsel is denied.
I'd like to submit another motion.
Okay, so you can't submit a motion because you have counsel. So if you would like to speak to Mr. Gill or forward those documents to Mr. Gill, then you can do so, because all other documents are a fugitive document since you have counsel.
Thank you, Your Honor. Your Honor, he hasn't come to see me. He hasn't talked to me on the phone. He does nothing. I don't see how a court can appoint a lawyer. You appointed him 2 months ago. He has yet to see me, yet to talk to me. He sent 2 flunkies from his office over to talk to me. I have sued him I'm suing him. How can you have a lawyer that's being sued?
It doesn't
that got
matter,
two-
Mr. Davis, it doesn't matter who I appoint you. You're going to sue them. That's your game that you play. We're no longer playing. You can go to Central Calendar Call on September 30th. We're done here. Thank you.
Okay, thank you, Your Honor.
Your Honor, would you be able to call page 30 if it's...
342946, Data Matter versus Raymond Davis. Mr. Davis?
Good afternoon.
Mr. Davis is present in custody.
How you
Do I have
doing?
Mr. Gill on Blue Jeans? I do have Mr. Gill. Can you hear me?
Yes, Your Honor.
Good. Do I have Ms. Collins? Can you hear me, Ms. Collins?
I can, Your Honor. Good afternoon.
Good afternoon. This is time set Central Trial Calendar Call. My notes reflect you're originating out of Department 6, Judge Bluth, for trial on Monday. There's a pending pro per motion to dismiss counsel. I've been through the register of action, ladies and gentlemen, and this case has the highest priority in the stack for Monday. Are the parties prepared to proceed?
Yes, Your Honor.
I am, Your Honor. The only thing I'm going to need to address with Judge Bluth, and it's probably going to have to be on an OST, is I have a couple people that are unpredictably going to need to testify by video, is my belief. I don't know if that rule is suspended, if it still needs to be handled by motion. Other than that, I can be prepared to go forward.
And how long do you anticipate taking? I know this case was mistried at one point. I was going back to the register of action to try to get a sense of that. I would bet that Judge Bluth does too, already has one. But for our minutes, how long do you anticipate taking?
Well, Your Honor, it was pro per defendant last time. I hope that we can get it done by the end of next week.
Okay, but it's a 5-day trial.
I think that's doable.
Your Honor.
Okay, hang on, Mr. Davis. I'll be with you in just a second. But we'll note that parties believe it might be done within 5 days, but so I can't stack anything behind it, is where I'm at. All right, Mr. Gill, any comments? Are you prepared to proceed?
Yes, Your Honor.
Okay, Mr. Davis.
Yes, Your Honor. I would.
Pull the microphone down, sir. I can't.
Your Honor, I would like to exercise my Sixth Amendment right to waive counsel. I do not want this lawyer representing me. He has not spoken to me about the case. I haven't. He spoke to me. I saw him one time in the last 3 months. He was assigned July 13th. He came to see me 2 days ago. He has no knowledge of the case. I would like to exercise my sixth constitutional right and waive counsel. I am sound, fit, making a firm decision. I would like to go forward. I'm ready, prepared Monday to represent myself. I'm of sound mind, body, spirit. I'm ready to go. All I need is the rest of the discovery, and I am ready. I do not want attorney Adam Gill, who was appointed by a judge that I have a lawsuit against, 2 lawsuits against, and I have filed a lawsuit against Adam Gill. Also, I have filed a complaint with the Nevada State Bar against attorney Adam Gill. I have a lawsuit pending against an attorney that is trying to represent me. I sued him for ineffective assistance of counsel, neglect. I do not want him representing me, Your Honor. I would like to waive counsel, represent myself. I put in 4 motions to remove him as counsel. 4. He is being forced on me. This is forced counsel, a violation of my constitutional rights.
Mr. Davis, I'll have the minutes reflect you've renewed your motion to dismiss counsel, which, based upon my review of the Register of Action, has already been heard and addressed by Judge Bluth. From reviewing the last effort that resulted in mistrial, it was Judge Bluth's decision that Mr. Gill should be appointed to represent you so the action can be a constructive effort this time. So
Your Honor,
I am not going to decide your motion to dismiss and your motion to move forward to represent yourself. Judge Bluth's responsibility is to do that. My responsibility on this calendar is to prioritize the cases that can go in the COVID-compliant courtroom. Yours is the case that goes. Now, that doesn't mean that you can't renew your efforts with Judge Bluth and make sure the record is clear on her decisions. But at this point, I'm not going to address your motion to dismiss.
Yes, Your Honor, the motion is pending now, and the lawsuit is pending now.
Right.
So I find that a conflict of interest when the client is being represented by attorney he is suing. And also, it's a conflict of interest that I got a complaint with the Nevada State Bar.
I understand.
Officer,
I understand.
Your Honor, this is an attempt to railroad me to prison because I won't take a deal. I want my trial. I want to represent myself. I have been appointed 5 different attorneys by Judge Jacqueline Blue. 5 different attorneys. Out of those 5 attorneys, for the whole in 1 year, I have been appointed 5 different attorneys. Out of all those 5 attorneys, ask Adam Gill, has he filed a motion? Not one motion in a year was filed on my behalf by the 5 attorneys appointed to me by this judge. None of them came to see me. I got a total of 3 minutes worth of phone calls out of 5 attorneys. This is an injustice. Your Honor, you as well as I know, a conviction cannot stand when a defendant has been declined his constitutional right to waive counsel. This is a constitutional right. I have a right to have my voice heard in court. I have a right to file motions that I want. Not one motion he has filed, he don't even answer the phone. His staff told me not to call his office anymore. The day they appointed him. How is this effective? You could send somebody to trial when an attorney hasn't even talked to him.
All right. Again, Mr. Davis, I'm noting your desire to have Mr. Gill's representation. You wish to dismiss him again. It's Judge Bluth's ultimate decision on whether the action moves forward with Mr. Gill or in what capacity Mr. Gill serves. Not mine. All I can say is you're number 1. On Monday morning, the matter begins jury selection in the jury commission or the jury services room.
So my constitutional rights to waive counsel is being denied.
You have a constitutional right to object to Mr. Gill representing you, and you've built, frankly, a sufficient record on the basis for that request. It's
and that's what I'm
up to Judge Bluth to make that decision.
Your Honor, Judge Bell is the one who had this trial set. I got the calendar right here, and it's supposed to be saying under Judge Bluth. I have a $5 million lawsuit pending against Judge Bluth. So now a judge that got a $5 million lawsuit pending against her is going to hear a case. Your Honor,
she is your presiding judge until or unless she's removed, and that has not happened.
Okay.
All right.
Yeah.
That's a simple answer. I mean, you are not the first individual, frankly, Mr. Davis, who has filed a civil action against either a presiding judge or a lawyer that they disagree with who's been appointed to represent them at taxpayer expenses. It's been done before, and answers to those questions are made a part of the record, and depending on what the ultimate outcome is in the case, it's a matter of appeal. I note in the Register of Action, you've sought appeal and writ of mandamus on multiple occasions with the Supreme Court. It's a matter of public record. So it's clear to me that you understand how to exercise your rights and try to enforce them as you see them.
Yes, Your Honor, but how can you exercise your right when you're up against a judge that got a strict bias for you, that abuses her discretion, that has been told by the Nevada Supreme Court?
Mr. Davis, I've given you your time.
Oh, thank you, Your Honor. I appreciate it.
On Monday, you're headed to trial.
Okay,
right?
thank you, Your Honor.
Very good. Next case. Lawyers, anything else?
I'm sorry, Your Honor. I don't mean to interrupt, but can we do the COVID canvas for the
thank you.
minutes?
Ladies and gentlemen, Mr. Davis, if you come forward again, sir.
Yes, sir.
All parties must understand that due to COVID coronavirus precautions, you will be required to wear a mask at all times during the trial. You should also understand that all witnesses, including alleged victims, will be required to wear a mask at all times during the trial. Do you all agree to wear a mask?
Your Honor, a mask on a black man is kind of like prejudicial.
Everybody's wearing a mask.
Yes, but I mean, I'm an African American male wearing a mask. That kind of makes a person look guilty. It don't make you look guilty. You're a white male. I'm an African American male. Juries tend to stereotype. People stereotype black people, as you know, are stereotyped for wearing masks.
Right. So I'll take that as a no, Mr. Davis, that you're not willing to wear a mask. Is that correct?
Your Honor, I like to go to court without a mask. I like to go to trial without a mask. I'll take my risk on the health because I want the jury to see my face.
All right. I'm just making these entries, and Judge Bluth is going to rule on whether that warrants a continuance of the action Lawyers, do you agree to wear masks?
Your Honor, if it warrants a continuance, I will wear a mask.
Because that's what would happen.
Okay, I will wear a mask.
Okay. Lawyers, do you agree to wear masks? Mr. Gill?
Absolutely, Your Honor. Mask or a shield.
All right, mask or a shield. Frankly, that's your choice too.
Okay.
Mr. Davis? Do you understand?
Yes, Your Honor, I'll wear a mask.
Very good.
May I get a time in jury services? I didn't get a time.
A few more questions that I have to build the record on, consistent with Judge Bell's direction. You should understand that all witnesses, including the alleged victim, will be required to wear a mask at all times. You should understand that all participants in the trial will also have to wear masks, including jurors and court staff. You understand the public viewing of the trial will be through a live video feed, and no members of the public will be able to sit in the courtroom during the trial. I think that's one of the more interesting components of the COVID requirements. If you have witnesses who wish to participate, Mr. Davis, if you have people that want to observe the trial, make sure that the court staff is made aware so arrangements can be made so they can view the action remotely. It's an open and public courtroom, and we use technology to make sure all have access. That goes for you too, Ms. Collins, if you have people who wish to observe the trial.
Your Honor,
Yes.
frankly, I would even like to challenge the jurisdiction of even having a trial for me. I have not been grand jury indicted.
Mr. Davis, we're not going backwards.
Okay,
right?
I just want to make that aware to you that I have not been grand jury indicted.
All right. These are the conditions that are outlined. So be prepared as you move forward in the action to comply with these directions from the court.
Yes, Your Honor.
Now, Ms. Collins, you indicated you had some additional scheduling concerns. It's a 9 o'clock jury selection on Monday morning. If you have not had an opportunity, both you and Mr. Gill should take every opportunity to go up and look at the courtroom. It's 3F that the action will proceed in. There are barriers set up to bring it in, again, efforts to comply with the governor's directive regarding social distancing, both through selection, jury selection, and presentation of evidence. So I strongly encourage you to go look at the jury commissioner or jury services room for selection at 9 a.m. and then head over to Department F to look at the courtroom. In fact, there's a trial going on in that courtroom right now. So it'll give you kind of an opportunity to understand the layout and give you, again, insight on how you'll be able to present your case. Ms. Collins, any other questions in terms of timing?
No, if there could just be a note placed in the minutes to call up the evidence for the department so that they know. The evidence from the previous trial.
Okay.
This trial.
The court clerk. Kim, how do we communicate with the court clerk for 6 to make sure the evidence is there and ready?
I'll send an email to the department, Your Honor.
All right.
Thank you.
Good. All right. Anything else?
No, sir, not by the state.
Right.
Thank you, Your Honor.
All right, Mr.
Thank
Davis. Take care. All right, moving to page.
I actually have one more case.
Thank you very much, Your Honor.
You're welcome. Raymond Tyrone Davis, C342946-1. Mr. Davis is present via Blue Jeans, out of custody. Mr. Gill on his behalf, out of custody, or excuse me, yeah, Mr. Gill is out of custody. He is present via Blue Jeans, and then I have Mr. Rolls present as well, everybody via Blue Jeans. Okay, so I did receive the supplemental PSI. I have had the opportunity to go through it. This was both parties stipulating to the defendant receiving probation with the only condition that he served 380 days in CCDC, which he has already done. Is that still the status of the negotiations, Mr. Rolls?
Yes, Your Honor.
All right. Okay. So I plan to go along with the negotiations, but I am happy to hear if anyone would like to hear, if anyone would like me to consider anything else first, Mr. Rolls.
No, Your Honor. We'll stand by the negotiations and ask that you follow them.
All right. Mr. Davis, would you like to be heard in any manner, sir?
Yes, Your Honor. Can I be heard? Can you hear me?
Yes, I can hear you. Go ahead, sir.
Okay, Your Honor. Since I've been out, I have donated to quite a bit of charities, St. Jude's, Children's Hospital, and I have also enrolled in college. I am now a student
I have a student ID number. I'm going to college. I'm going to Grand Canyon University for law. This case has really opened my eyes to the legal system, and I want to help people. I want to be a productive member of society. I'm going through some serious health issues right now, and some serious mental issues. I'm under doctor's care. My doctor is Ernest Bagner. I'm basically I totally isolated myself from the world. I'm fearful of society. It's just I'm in a bad place, mentally with this case and everything that happened. And then everything that has went on and I would like to apologize to you for my behavior in court. I was definitely going through some post-traumatic stress disorders and some mental issues I was battling. But it's a lot of things in this case that wasn't brought out and stuff like that. And I have been trying to talk to Adam and stuff like that, and it's been hard to communicate and stuff like that. But it is what it is. I think the court gave me a favorable deal. I mean, a district attorney gave me, and I definitely appreciate that and stuff like that. Yeah. So what I want to do is apologize. I want to also thank your staff for helping me through in some difficult moments, especially Crystal Jacobs and stuff like that. She helped me through some things. And I just want to move forward with my future. My family's struggling. My sister's having breast surgery in 3 or 4 days, so I got to fly down and help them. My family's struggling not only financially, but also health-wise. So I'm under so much stress, so much pressure now. I'm just happy that this is basically going to be over. I moved it. I basically don't go out much. I've probably been out 10 times since in the last 4 months. I don't go out only rarely. So it's just I just had another COVID test and stuff like that. I just want to get mentally in a great spot, get back in my mental spot. I just don't want to hold no grudges or hold nothing against you or your court, and I want to apologize for my behavior. I know a couple times I was out of line, but I was going through a lot of things that didn't pertain to the case. My son was planning suicide. He wanted to go to Europe and kill himself and stuff like that. There was a lot of things that was going on at the time of the case and stuff like that, and I was very upset because I really don't recall a lot of the history of these meetings or whatever. But I was in an accident. Everyone knows I was in an accident in 2016. So my memory isn't as clear as probably possible. But basically, I would like to apologize and stuff for any kind of disrespect or any kind of behavior I had towards you. I think you're a great young judge, and I wish you nothing but the best for the future. I don't listen to several cases, and I find you fair. That's about it. I gotta say, and like I said, I'm moving forward. I'm going to college. I'm doing online courses now. My chosen livelihood is struggling now, obviously with the casinos closed and stuff like that. So basically, I'm doing some counseling and some advising and stuff like that, trying to bring up income. But obviously, I'll never get back the income I had before. So I decided to take the route to go to college and try to learn law and become a lawyer and be in the system because it's something that I enjoy. I mean, not my part of being in it, but I enjoy the theatric of courts and, the inner working of it and stuff like that. And I feel I can be an access. So I definitely start school on the 8th of this month, and looking forward to representing some people and being a productive member of society. That's about it.
Well, thank you. I appreciate all of your sentiments, and I'm sorry that you are going through what you are going through, but I wish you the best in continuing on with, mental health therapy and also college. So good for you. Mr. Gill, is there anything you wanted to add?
No, Your Honor, with the state submitting, I'll do so as well.
All right. In accordance with the laws of the state of Nevada, you are hereby judged guilty of the crime of count 1, coercion, and count 2, contributing to the delinquency of a minor, in addition to the $25 administrative assessment fee, the $150 DNA fee, the $3 DNA collection fee, and the $250 indigent defense fee, and the fact that you must submit to genetic marker testing. As to count 1, you are sentenced to a minimum of 19 months, a maximum of 48. That's suspended. You're placed on a period of probation not to exceed 24 months. That the only condition of that probation being that you serve 380 days in the Clark County Detention Center, which has already been served, so you get credit for time served for that, as well as the misdemeanor 6 months, which has already been served. So that is the total amount. So you receive CTS on all of your charges, and your case is closed.
Thank you, Your Honor, and the best for everyone. I wish everybody the best. I really appreciate it. Thank you, Adam. Thank your staff. Your staff is wonderful. Thanks for everything you guys have done.
All right, I will.
Thank you.
Thank you, Your Honor.
Hey, Mr. Gill, sorry, and Mr. Davis, one quick question. So when we were in that first day of trial, Mr. Gill, you had taken a few of the exhibits and let Mr. Davis look at them in trial, and then I don't think anybody's fault, but Mr. Davis then had taken them back to the jail with him, and so I just need to make sure it's on the record that it's okay that we withdraw those from evidence since I no longer have them in my courtroom.
Thank you, Your Honor.
Okay, all right, so those will be withdrawn. Okay, all right,
Okay,
sounds good.
thank you, Your Honor.
All righty, bye-bye. All right, let's go to...
All right, looks like Mr. Gill's got a couple of things, so let's start off with Mr. Davis. State of Nevada versus Raymond Davis, page 3, C342946. Stand by, let me just turn to that page. Let's see. Oh my goodness. Hold on just for a second. Oh, it looks like I can't get to it. Oh, yes I can. Sorry. There's an app that I use to complete the task, and I'll go ahead and open that at the same time. So it looks as, is Mr. Davis on the line? Do we expect him to be present?
I don't believe so, Your Honor. I just got told about this hearing a few minutes ago, so I can't believe, I can't imagine Mr. Davis was aware.
That's okay. So it's my understanding that Parole and Probation has petitioned the court noting that he has successfully completed all of the ordered conditions, and therefore they are recommending an honorable discharge from probation pursuant to 176A-850. I am going to grant that request. Stand by, hang on a second. Nope, wrong one. Huh. All right. Hang on, everybody, I'm begging your pardon here. Okay, it's in a different place. Well, it looks like I don't have the ability to do it from the bench, which is a little bit weird, but anyway, so I'm granting that, and as soon as I can figure out where to go, I'll sign the order. Is there anything else on this case from either Mr. Rolls or Ms. Pekovich?
No, Your Honor, thank you.
So if
I don't have anything on it.
If we could move on to Ashley Dungy on page 7.